Hello, everyone, and welcome to another installment of the Maryland Volunteer Lawyer Service and Human Trafficking Prevention Project's quarterly webinar series. I'm very excited to be here with you today. My name is Heather Heiman. I am the HTPP Partnership Manager over at Maryland Volunteer Lawyer Service and a staff attorney there as well. And I'm here with my colleague, Jessica Emerson, the Director of the Human Trafficking Prevention Project. We are, like I said, very excited to be here today. We're retreading some ground that we've had before. We've trained on this subject a lot, talking about criminal record relief here in Maryland. But we thought it was time to do a new course for folks who might be new to these forms of legal relief. And because the law is constantly updating. And so it's good to just have an opportunity to discuss what remedies are out there and answer any questions, go over details, and hopefully make everyone better informed and better able to just understand, if you're an advocate, how to help clients get assistance with these kinds of matters, or give them some guidance or some resources. If you're an attorney, better understand how to actually do filings, issues you might encounter, and for any survivors, other community members, just it's good to know about these kinds of laws so you can help spread the word about this important these important forms of criminal record relief. The webinar is being recorded, and we will be having it available for public view. So if you need to drop off early, it will be on both MVLS's and the HTPP's website, probably in the next month. And we'll also be putting out a tip sheet that summarizes some of the most important points. I definitely want to encourage folks to ask questions in the chat. We'll be keeping an eye on it as we go through, and we're always here as resources. If you think of something later, feel free to email us. So, and then Jessica, just say a quick hello.
Hello, everyone. So glad to be back with Heather talking about our favorite topic. Although, is trauma our favorite topic, or is this our favorite topic? I'm not quite sure.
I think this is my favorite topic.
Well, all right, legally, this is my
Remedies.
favorite topic. Non-legally, trauma is my favorite topic. And as Heather said, yes, there is some repetition, but there has been a lot of updates to the law since we last did one of these trainings. And we have, again, we've integrated a lot of new material. And we're constantly looking for ways to basically help folks with whatever is on not only their criminal record, but you'll see even we're addressing things related to failure to pay rent. And so it really is about making things as easy for our clients and anyone to improve their employability, improve their ability to access safe housing, things like that, because we know that those things are what help folks who have experienced trafficking not experience it again. And we know that for folks who have not had those experiences, it puts them at decreased risk of ever experiencing that in the first place. And that is the goal of the HTPP. So let's get into that. So for our agenda today, I'm going to give a brief introduction to the HTPP and our partnership with MVLS. Then we're going to start talking about criminal record relief in Maryland. We're going to talk about expungement. We're going to talk about shielding, and in particular, the Second Chance Act, shielding of peace and protective orders, and shielding of certain landlord-tenant cases. And we're going to end with vacatur of convictions that are specific to human trafficking survivors. So who are we and what the heck do we do? We primarily serve anyone across the gender spectrum who has experienced sex and/or labor trafficking. Now, if anyone is on the webinar who says, well, I would like to know a little bit more about that, you are not going to learn that today. But we have webinars on the HTPP website that links to MVLS's website. All that information will be on the last slide, and you can learn all about that on our webinars, on our tip sheets. And if you are interested in getting a very specific training on that, feel free to reach out to us. And again, our contact information will be on the last slide. So anyone across the gender spectrum who has experienced sex and/or labor trafficking, or who has traded sex for any reason, including those who trade sex by choice, folks who do so out of circumstance or due to coercion, folks who have been trafficked. For clients who meet the above parameters, we offer legal representation in criminal record relief matters. That is our expertise, such as assistance with expungement, shielding, and vacatur. But we also help with a range of civil legal issues like consumer debt matters and credit repair. That is Heather's expertise. Family law matters such as divorce and custody, name and gender marker changes, as well as tax controversies. And we are able to do that through our exceptionally valued partnership with Maryland Volunteer Lawyer Service, which is the largest provider of pro bono legal services in the state of Maryland. And you're going to learn a little bit more about MVLS in 2 slides. So that is primarily what we do. But we've also got the word prevention in our name. So what is the point of that? We also focus on preventing exploitation. So we do work primarily with survivors of trafficking, but we also work with folks who are put at high risk of exploitation. And the way that primarily that we focus on preventing exploitation is, again, through criminal record relief. So as a program that also focuses on trafficking prevention, us and our partnership with MVLS, we also provide criminal record relief services to individuals who have been subjected to a combination of violence, trauma, and other systemic inequities that put them at increased risk of exploitation, including interpersonal violence, sexual assault, housing instability, substance use disorder, prior involvement in the criminal legal system, folks with challenges with their immigration status, and or discrimination based on race, sexual orientation, and or gender identity. So for instance, we might work with someone who has a past history of substance use disorder, who is struggling with housing instability and has a history of sexual assault and interpersonal violence. We will work with that individual, even though they have never experienced trafficking, to address their criminal record, because we know that that person, unfortunately, is ripe for exploitation. And we want to make sure that that individual, again, can access choices. That is the point of the work that we do. We do not define our clients' experiences for them. We do not tell them what choices to make about their lives, but what we do want them to have is choice. And the reality is that when you've had these experiences and you add a criminal record to that, your choices of what to do with your life are dramatically decreased. And so when we can help someone clear their criminal record, we have opened up avenues for people to live their lives the way that they want to live them. And that is why we do the work that we do. And the next slide is about Maryland Volunteer Lawyer Service. So I'm going to turn it over to Heather, and then she is going to take us into the beginning of our expungement training.
Thanks, Jess. So I hope many of you are familiar with Maryland Volunteer Lawyer Service, which is the largest statewide provider of pro bono legal help here in Maryland. And we assist with all different kinds of cases. With our partnership, as you can see from this list on the slide, with our partnership with the HTPP, our approach is to really do a deep dive with clients. And of course, I think that's something that all of us as advocates and attorneys wish we could do with everyone we worked with, right? But for all the reasons Jess just stated, like we really do try to do a very comprehensive look at everything we can possibly address or assist with for the clients that we're working with through our partnership. And that's a great thing for us that we're able to do that. And that's kind of the approach as we're talking about these different forms of criminal record relief. It's with the eye to kind of really leveraging every single law we can here in the state to take as much possible off of people's records. And so that's why we're discussing all of these different forms of relief. And there's ways to make direct referrals to our partnership and to the HTPP, but of course, anyone subject to some income eligibility is able to reach out to MVLS for help. You can see our information for applying online for services, as well as our intake line, which is open Monday through Thursday in the mornings. So you don't have to have any other kinds of qualifications. You can just reach out and get help from our amazing intake team. So we're going to dive right into expungement. It's funny, as I was quickly reviewing these slides, I realized that we should have maybe included a slide on how people can actually get their records. I think we have something on it a little bit later, but I wanted to just mention that for a second before we dive into exactly what expungement is. So as most of you, I hope, know, or maybe you're not familiar with this, but in Maryland, it's fairly easy, not as easy as it used to be, but fairly easy still to be able to see folks' criminal and civil legal records. Maryland Judiciary Case Search is a publicly available database that people can go to, and you can look up anyone by name, sort by date of birth, by case type, and see a lot of people's histories of interaction with the criminal and civil legal system in the state. A number of years ago, you used to basically see almost everything on that database, including, non-convictions, convictions, all kinds of other outcomes. If you've been sued for debt, just the whole host of cases. Laws passed in the last few years, which we will discuss, have kind of shrunken exactly what can be seen via Maryland Judiciary Case Search, which is both good and bad. That's kind of the first place that people go. And often when we interact with folks, they'll be like, oh, I saw I have cases on Maryland Judiciary Case Search. And that's one place that you can get information about your or someone you're working with criminal records. Again, with the idea of doing a deep dive, we usually like to try to get a fuller picture of information. Jess and I, we have access to things like Westlaw People Finder, MDEC as attorneys. There's ways to get different background checks that we'll talk about. But here in Maryland, the reason I say all of this is I think right now there's a little bit of confusion about what's publicly accessible, what's not, what may show up on a background check. And my caution is you can't really rely on one thing anymore. It's best to try and gather from multiple sources to really understand what records a person may have. And as we'll discuss as we go through these different remedies, how they interact with each other to either be eligible for expungement, not maybe be eligible for another form of relief. Are they blocked? There's a lot of analysis that has to be done in some ways that is in many cases kind of making it challenging for a layperson, for someone to just figure out on their own. And that's why getting attorney assistance can be really helpful. So
Heather, I like to think of it, I know this dates for the young folks that are on the call are not going to understand this, but folks our age, it feels like tracing paper. Now you put one down and you put another down and you put another down, and then all of a sudden you have a full picture. And it takes longer now, but thankfully it's a little harder to see everything in one shot.
yeah, it is.
But what it has done is made it a lot harder for the layperson to see what is on.
It has. So we'll dive into at least try to unpack this a little bit. But I would strongly encourage folks, there's lots of legal service organizations out there besides MVLS and HTPP, Legal Aid, Homeless Persons Representation Project. There's tons of orgs throughout the state that can help with these kinds of issues. So, all right, what is expungement? Why is it important? Jess, you added in that?
Of course, I just
we have an ongoing battle.
I didn't put them in all of them.
We have an ongoing battle about whether the whole slide should show or it should be shown in teasing. All right, so let's define.
You have a poll.
So expungement is the removal of information from a case from court and law enforcement records. That includes like literal paper files from the court, from Maryland Judiciary Case Search, which we just talked about, from Criminal Justice Information System, MDEC, anywhere that information about a particular arrest, case, conviction might be held. Expungement essentially removes that information. So why is it critical? We already touched on this a little bit, but A lot of the stuff is publicly available, and it's less so if the resulting case didn't, if the case didn't result in a conviction. But there are, in addition to all of these databases we've already talked about, there's background check companies, there's bots just scraping the internet for all of this data. And so if you've had an interaction with law enforcement or with the legal system, it is likely out there somewhere. And so we need to understand how we can address it so it doesn't impact people's lives going forward. One thing that makes expungement and shielding great tools for us is if a record has been expunged or shielded, you do not have to disclose that on a job application or during interviews per Maryland law. So that's a huge advantage for folks, again, to make it easier to access stable employment, safe housing.
And I think what I always tell clients, first of all, there's a lot of misinformation about, for non-convictions versus convictions. I've never met anyone who thinks that their convictions are no longer on their records. I've definitely met a lot of people who feel like their non-convictions will fall off, and that's understandable. But I think what is most important for about non-convictions is that your average lay boss or lay landlord or whoever is looking at your record is not going to be like, oh, well, that's just a null pros. And that means that the state's attorney declined to prosecute. Or, wow, that's 5 dismissals for X, Y, and Z. Like they're not, people are not the lay person is not reading someone's criminal record for context
Yeah, they're just
like
going to
I
see
am.
second-degree assault. They're going to see
Yes,
trespassing. They're going to
exactly.
see
Like I
whatever it
look at
is.
a I look at a record, for instance, for a new client, and I'll see fourth degree burglary, drugs, prostitution, and trespassing. And that to me paints a contextual picture of someone who is unstably housed or struggling with homelessness, substance use disorder, survival sex work, possibly trafficking. Like there's a lot of context in there for me. That's not what your average bear is likely seeing because we all have our own rose or non-rose colored glasses in this in this example. And there's a lot of judgment that people will take based not on the outcome of the case, but on the charge. Like you said, with second degree assault, you may not know that I was defending myself against my partner who has been abusing me for 10 years, right? I'm just seeing multiple second degree assaults. And you're not necessarily seeing all of, the context that I was talking about. You're just judging me for those charges. So that's really important. And that's why it's important to get those charges off there.
Right. So under Maryland law, what can be expunged? We don't have the best expungement laws in the world, but we don't have the worst. And the categories are constantly growing due to tireless advocacy by folks all across the state from many walks of life who are really trying to expand this legal remedy. So right now, most non-convictions can be expunged, acquittals, not guilties, dismissed, null pros, stats, probation before judgments, or some caveats with some of those for either criminal cases or if it's an incarcerable traffic offense. And that means a traffic offense where there is the potential to have jail time as an outcome of that case. Doesn't mean that jail time,
Don't have to be. Yeah.
yeah, it doesn't mean that it has been necessarily imposed, but it could be. And for cases where there is not a risk of jail time, where it's a fine, there's a multi kind of year process by which the case will drop off of a person's record. There's a limited number of misdemeanors and a very limited number of felonies that can be expunged when there is a conviction in the case, including convictions for so-called nuisance crimes. There's certain
I hate that word.
Yeah, there's certain situations where a court has found someone not criminally responsible. Those can also be expunged. And then there's crimes that are no longer a crime. This is something that's been a topic here in Maryland a bit over the last few years because of changes in the laws around marijuana use and possession. And so right now, before there were many people had arrests, had convictions for these two things, and now all convictions for possession of marijuana are actually considered a crime that's no longer a crime and are immediately eligible for expungement and should begin to be automatically expunged as well. However, in most cases, it's a little more complicated. So if there, for certain non-convictions for probation before judgments, and then for convictions, you have to almost map things out and look at a bunch of additional considerations to see if this particular case is eligible. There's wait times before you can petition for expungement. There's rules around not having things, a subsequent conviction within 3 years after a prior one that'll negate the eligibility. And this is where things get tricky and where a lawyer can be helpful.
Yeah, and where we can't teach you every little thing because
Mhm.
it's A plus B equals C in some cases and D in some cases and E in others. So it's a little bit of it's like a puzzle.
Mhm. Mhm. And you can see here the list. This isn't a totally comprehensive list. This is the list that we see the most often. So we're sharing it as an example of convictions that were made eligible for expungement under the Justice Reinvestment Act. I think was that 2017?
2016 and it went into
16 went
effect.
into effect 2017. Yeah, so it's under code 10110. And you can see there's a lot of things listed here that are things we commonly see people arrested for. And then if you have a conviction as the outcome, you can ask for these things to be expunged. Now, again, there's some interplay, right? If you have 6 different records and there was a conviction for one, say in 2010, and then there was a conviction for another thing on this list in 2012. Well, that 2012 conviction makes the 2010 one ineligible until the 2012 one is eligible. So we begin to have this almost cascading effect that we have to look at when we're evaluating eligibility. And that can make it a little bit tricky, but not impossible to do.
And then again, you can see 5 additional felonies added, misdemeanor theft and felony theft.
Mhm.
And so it's personally, I am not a fan of this pick and choose
Yeah,
because there is
we wish it was.
always a client with something that falls slightly outside, like
Yes.
trespass on posted property versus private.
Mhm.
But this is the way that Maryland has decided to do it at this point.
And again, the list is constantly expanding. Like looking at one of the last ones that we put above the felonies, malicious destruction of property. That's a relatively new addition to the list, and I can tell you, we had lots of clients
Yeah.
who we had to consider whether shielding would be an option for malicious destruction of property because it was eligible to be shielded but not expunged. Now it is, and that like opens up a whole new world of us for not just getting that particular record expunged, but if that was blocking other prior convictions for different people. So again, it's this game of constantly examining what's eligible and almost mapping it with the client that you're working with.
And I would say it's nearly impossible to do this on your own. Even sometimes for us, I need a second pair of eyeballs,
Yeah.
you know?
All right, so we wanted to highlight for you some recent changes to Maryland expungement law and process. As I stated earlier, there have been some changes to key search, which again, in some ways are great, in some ways make things a little more challenging. We're trying to get a comprehensive view of folks' records. All non-convictions are no longer visible. Actually, it's not all. 3 non-convictions are no longer visible on case search. If there's been a finding of not guilty, dismissed, or null prosequi, then those types of records should no longer be visible on Maryland judiciary case search, no matter when it happened. It goes back through time. They just removed all of that from the publicly viewable part of the database. And we're in this interesting new period now too, where certain cases in Maryland are beginning to be automatically expunged. So this law was passed back in 2021. legislative session, and it went into effect on October 1st, 2021. And what the law said is that when there are eligible non-convictions, again, acquittal, dismissal, null process, where the disposition was entered after the law went into effect, so after October 1st, 2021, 3 years after that, these cases would begin to be automatically expunged. Well, October 2024 is that 3-year period is supposed to be starting. And we've already seen some cases like this coming through at MVLS where we thought something we were going to have to expunge, and then it suddenly the record was no longer there. So we do know that it is being implemented. How consistently and widely, I can't really tell you right now. It's something that we'll be, continuing to follow up with folks that we know from the courts. But it is an exciting development. Now, I think it can also create some confusion. I've talked to folks just when we're doing outreach and advocacy that think that now everything's going to be automatically expunged after a certain amount of time, or that you can't expunge earlier because there's this 3-year period and then the automatic expungement happens. And this is all not true. It's only for certain dispositions. You can request to expunge cases like this earlier than 3 years from right after the disposition is given, actually, as long as you agree to sign and submit a waiver of liability, basically giving up your rights to sue the law enforcement agency that was involved in your arrest. And there's also still the caveat too, that if the non-conviction is part of a unit of charges, so say there's a criminal case, there's been, 4 separate charges, 3 were null prost, but 1 had a guilty verdict of conviction. Those 3 charges, that little section is now hidden from public view. It's not automatically expunged, it's just shielded so people can't see it if they look up that case number, but they're not entirely gone. And again, these situations where there's units, multiple charges in a case, or where there's cases that are related to each other, those all interplay with each other to affect whether they're visible, whether they're eligible for expungement, and how they impact other criminal cases that the individual might be wanting to expunge.
Now, I will say that what I refer to as the Maryland Expungement Coalition, which includes the HTPP and MVLS, and is headed by our fearless leader, Chris Dews, have been fighting for a change to the unit rule, to basically extract that unit rule and be able to kind of pull those non-convictions away from the non-expungible pieces of a case. We've been fighting for that for years, getting closer and closer. We keep being told it's it's kind of technologically not possible. And last year there was a bill passed that said, any advancements to the technology of the judiciary have to be able to basically do this in the future. So I think we're heading there. I don't know if it's a bit of hedging. I can't read it, inside people's minds, but I know that we are getting there. I think that we are getting there. And the point is to be able, eventually to say in that case that we can extract those non-convictions and then just keep that conviction there. But the challenge again then is in the paperwork. How do you extract the written material that led up to those non-convictions? And so there's a lot that goes into that, but that is top of mind for the Maryland Expungement Coalition, as I like to call us.
Yeah. And as Jess said earlier, one of the reasons this is so key is sometimes there's just a whole bunch of charges thrown at people, right? And then there's something negotiated. There's, convictions for certain things, not other things are pled down. And it doesn't matter though. If somebody's able to pull up a record and they see assault with a deadly weapon and, all of these more serious charges, and then these weren't convictions for these particular more serious matters, and it was just something smaller, it still doesn't matter. It'll still throw up barriers,
Yeah.
roadblocks to folks. So.
One of my first clients was in a stash house, and she was there because she had a substance use disorder, and she was charged with guns and
Mhm.
drugs and
Mhm.
possession with intent to distribute and manufacturing and everything. And then, because they threw it, frankly, wasn't done in good faith.
Mhm.
And, at this point, yeah, as a result of number one here, you can't see that on case search, but there's nothing we can do
Mhm.
about all of the other stuff.
And when we're working with clients, often we're working with folks who are, so they're in a nursing program, they're anticipating beginning to try and get a job, and they need to be able to pass background checks and go through board certifications. And so these things rearing their heads can just be debilitating for folks.
Yeah. And I think it's a challenge when you are working in, a legislative sense where there are people who are working with folks who understand that context and folks who don't.
Mhm.
It's a challenge. All right, the Redeem Act. I still have to clap even though it was 2 years.
Ah,
I don't care. It
go
makes
for
me
it.
very
No,
happy.
that was really exciting a few years ago when these changes got made. They were long and hard fought to be able
Yes.
to reduce these waiting periods. And it's kind of self-explanatory, what you see on the slide, right? Waiting periods dropped, got cut in half for many eligible.
That one should have been 3, but
I know, but still, we're gonna applaud the progress, and hope for more continuing as we go forward. So eligible misdemeanors, the waiting period, so that the time after a disposition was entered, and then any kind of post-conviction obligations were satisfied, including any kind of time spent incarcerated, probation, that all has to be completed. Then after a certain period, you can request and petition for something to be expunged. Those wait periods dropped for misdemeanors from 10 years to 5 years, eligible felonies from 15 to 7. First and second degree burglary and felony theft dropped from 15 years to 10. Second degree assault and battery went from 15 years to 7. And then domestically related crimes stayed at 15 years, but still this was important movement to make this form of relief more accessible to people.
right. And if I can just put a plug in for those of you who are interested in this and who maybe either want to monitor legislative stuff or even get involved or submit letters of support, the name on everybody's lips has got to be Abhishek.
Mhm.
I want to put that into your brains. Abhishek. That is what we are focusing on this year. That is a case that said that all that kind of extra stuff at the end of a case that Heather was referring to, the periods of probation, everything like that. Essentially, that case said that if you violated probation for any reason at all, if you murdered somebody or if you missed a probation appointment,
Missed your
you,
bus.
which happens all the time,
Mhm.
you are never eligible to expunge your conviction, right? Think about that. That is, to me, it's unbelievably unjust. And so we are going to be trying our hardest to undo that incredibly unjust legal outcome. So the name on everybody's lips is gonna be Abhishek. So think about that. Thank you so much for indulging me there. Okay, some additional changes to be aware of. Just a couple things to go through. Go ahead.
Oh, sure. So the addition of malicious destruction of property, we already commented on this, but that was a great change that happened recently. We saw that so often. And again, that could be, I've had clients who have gotten that for, tossing a cell phone to something, much more serious. So it's good that we're able to address that through expungement.
But it's a
Um,
5-year waiting period,
it
which
is a
we're
5-year waiting
noting.
period.
We're noting it.
Yes, yes. Perverted practice being no longer a crime. This is something that's
That's a big
immediately
deal.
eligible. And again, in the context of working with folks who've traded sex or who may have experienced human trafficking, we did see folks that had these types of convictions. And this law was often targeting certain demographic groups. And so it's good that we're able to now get those kinds of records off
And
for people.
And what we mean is that if you see that on somebody's record, expunge. You don't have to
Mhm.
worry about what it says, immediately eligible,
Mhm.
immediately. Okay.
And then, as of a number of years ago, sodomy is no longer a crime as well in Maryland. Again, long overdue. There are some additional caveats that they put into the law, but again, these types of offenses were often levied against people, targeting specific groups. So we're really happy that these are being addressed. And another big and exciting update is now unpaid court costs are no longer a bar to expungement. That's something that we've seen frequently with clients. We don't want financial barriers to be preventing folks from moving forward with getting their criminal records cleaned up. And so that was a very welcome change. And then the last thing, this happened just in the last legislative session. There was a change and it went into effect October 1st of this last year, that probation before judgments for driving under the influence can be expunged after a 10-year waiting period. Before, I believe there was no expungement option, but prior to
Zero.
this,
That
right?
was
Yeah.
the one exemption or one exception
To the PBJ
PBJ.
rule.
Yeah.
Yeah. Because usually with probation before judgment, you would have to wait 3 years in order to expunge that disposition. In a DUI case. And there couldn't be a subsequent conviction within the 3 years. So there were caveats, but if it was a PBJ for a DUI, you just couldn't expunge it all. So now it's nice to have this carve out.
A little rough, but
Yeah, I mean, of course, we wish it was less. You know what I mean? But
yeah. But what was nice is that during the and again, I do not want anyone to think by me saying it's a little rough that um I'm taking driving under the influence lightly at all, right? This is not a conviction. This is a PBJ. Um, but what I do know, especially from our work with HTPP clients, is that drug and alcohol use is entirely tied to histories of trauma. And so just like with anything else, folks, need to be given the opportunity to explain that there's been changes in their lives and to have things, non-convictions for this tied to them for the rest of their lives,
mhm.
especially when so much of this, and we were able to have people testify that talked about how they were using drugs and alcohol to cope with tremendous amounts of trauma. We have to provide people with the opportunity and even more so the incentive to change and to heal and to recover, right? In recovery circles, we say we do recover. And the fact that people can now say, you know what, I can get this off my record. That is an incredible incentive to, continue along the journey towards recovery.
Great. Some additional recent changes to the law regarding expungement process here in Maryland. So as I mentioned before, this expungement of cannabis charges and convictions. As of I think 2 years ago now, convictions for possession of 1.5 ounces and under is now immediately eligible for expungement. It's considered in the category of a crime that's no longer a crime. And this affected so many people, and there's been a really widespread effort. MVLS is part of a cannabis coalition to try and get the word out that you can get these charges, you can get these convictions removed because they were on so many folks' records. And especially, it correlates with the war on drugs, it correlates with over policing. And so it's good that we're able to, that changes were made to be able to address this. There was a change with possession with intent to distribute. If it was related only to cannabis, it's eligible for expungement 3 years after completion of the sentence. So again, just giving some kind of option where there wasn't one before. And then this automatic expungement process is beginning. So basically the law changed to say that on or before July 1st, 2024, the court shall expunge all cases where cannabis possession was the only charge and the event occurred before July 1st, 2023. And it'll be shielded otherwise on case search. So
until
again,
they get to it.
yeah. So And this is, again, there's the court system's a huge bureaucracy. We can't expect everything to happen overnight, but these are changes that we are watching to see that they are getting implemented. It was interesting when they started shielding cases on Maryland Judiciary Case Search, because we began to just slowly see things disappearing when we were working with clients. And so it's going to take some time, but it's really exciting that these changes are afoot. There's, constant discussion now about, again, how to keep our technology updated and able to handle these types of changes in the court system and to the way that records are being kept. So I'm hopeful. I'm hopeful that this is going to, be a widespread thing. And again, it takes the onus off the individual person. Institutions should be doing these corrections. It shouldn't be on individuals to make
Yeah,
these fixes themselves, because that in itself is a barrier. It's
right.
scary going to court.
Yeah, if the system's to blame. It shouldn't be, the onus shouldn't be on the individual for what the system put upon them.
And we have a whole very detailed training
Yeah.
about these legal changes that's accessible on MVLS's website, so you can check that out. And we'll be sending out links to a whole bunch of things. MVLS is a very comprehensive library. If you're a practitioner and you want kind of a step-by-step guide going over the petition for expungement, how to file it, we have that as well. We're not doing that quite level of detail here, but we have those resources available.
Great. All right, so so Heather kind of hinted to it at the beginning that you may want to get your client a background check. Um, there's, we don't have any kind of like best practices around this. I kind of just go on gut in terms of, I'll ask questions of a client in terms of, and we'll get into this more kind of at the end, do you know where you were arrested? Do you know, essentially for me, it's have you ever been arrested in another state? Right. And now not every client knows that, and that's perfectly fine. But I definitely have clients who are like, listen, I have never stepped foot out of the state of Maryland. And in which case I feel comfortable saying, okay, I feel like I can get what I need from the systems that Heather already talked to you about. However, if I have a client with a very common name, if I have a Jane Smith, if I have a client who just for whatever reason has a ton of AKAs, right? Or either because they've given a lot of wrong names, or because for whatever reason there's a lot of misspellings. If there's any reason that I feel like I am not going to be able to maintain my sanity and be able to figure out exactly what's on this person's record, or if I know that the person has been arrested in another state or has been trafficked in multiple states, then I am going to get the client a background check. And especially just because it's not painful and it's not expensive, why not do it? Right. And so you can get a background check even federally, or just through Maryland through CJIS, right? So this report will include any activity that involved being fingerprinted, even cases that are shielded on case search. So that's important to know. You can go to any authorized location that provides fingerprinting services in Maryland. That includes private providers. So if you're nowhere near like the main provider, I think is on Reisterstown Road, kind of like right on the border of the county and the city. But you can use that website to find places, and they have authorized private providers. That's totally fine. If you just want a Maryland background check, it's around 38. If you want a federal, it's 52, and you want to request that record for individual review. Payment can be confusing depending on the provider, so make sure you clarify that before you send your client or you bring your client to the CJIS location.
Just a quick note
Yeah,
on CJS, just to share, like we've had a number of clients recently who had older criminal cases, situations where they couldn't remember or
of course.
knew they had cases and just couldn't find the record anywhere. CJS is a great tool for that. And I've had folks who've been struggling to get into senior housing,
Yeah.
and it was due to outstanding criminal records that different government agencies were able to see, but they could not find the records of. And CJIS background checks will usually pull up most things. Now,
Yeah.
often you have to do a little bit of digging. They may not have the case number. They usually just have the fingerprint
Well, they
record
never
number,
have
the
the
tracking
case
number.
number. They always have the tracking number. And
Yeah, they
some
have
of
the
them don't
tracking
even
number.
have
So you have
that.
to, yeah, so you have to do some investigation. Often sometimes we have to go to the Maryland State Archives. But it's something that's cropping up more and more, I will say, especially as we're working with folks that are kind of hitting certain life milestones and then needing to supply documentation, or again, with the ubiquitousness of the internet, like so much is available to different state agencies
Yep.
connected to the court system, that it can throw up unexpected barriers for folks.
Yeah. And as the victims of the 80s and 90s war on drugs age, this is going to
Exactly.
become more and more of a problem.
Yeah,
Yep.
and we're seeing that where there was, a substantial overpolicing in Black communities, particularly,
Yep.
here in Baltimore City and other jurisdictions in Maryland. And so just keep your eye out for that. Don't think that because you can't find something on case search, and I'd say even Westlight, if you're an attorney, even MDEC, sometimes I can't find things. You might need to go a couple different routes to really help someone figure out what's going on.
Do your tracing paper magic. And again, it's you're going from the problems with a transfer of the paper file to case search, and then the problems from the case search to the MDEC. So you're gonna find problems there. Human error is human error. There's no way around it, right? It is what it is. I tend to go the easy route, which is an FBI background check nationwide.
This is my preferred method too now.
It's just
So
easier
yeah,
and
if
I
folks
can be
can do it and
lazier
are
and
willing.
right. Report will include criminal legal involvement in any of the 50 states. The findings can indeed be inconsistent with state records, though, as the database only reflects the information that's been provided to the federal government, right? I mean, in all honesty, the best way is like this and CGIS and, but there's only so much you can do without feeling like you're going overboard. What the company that we like is Fieldprint USA. It is a $50 flat fee. They have the digital fingerprints. I remember back when I started the HTPP, I used to walk around with like a literal
Fingerprint card,
stamp,
yeah, stack,
the
yeah,
card and a stamp in
yeah.
the bag, and just so that my clients wouldn't have to go, or I could fingerprint them instead of them
Mhm.
having to go to like the police station. Um, and the results are emailed to you usually in less than 24 hours. I've had
Mhm.
them in somebody's email when they left the place. A lot of
Mhm.
UPS stores are doing this now.
Yes, yes. It's less
Um,
intimidating to go get this done. It sounds scary, FBI
it's
national
not.
background check, but it's actually, in my mind, the easiest one.
And it's so you're not going to like a criminal justice information system place, which is an official Maryland state agency. You're going to UPS. It is easy. And it's $50. So again, that's our recommendation. You can use whatever is easiest for you. But we use
And
print.
I will say with field print too, another thing that I like about the reports that we get with the FBI background checks, and it doesn't have to be through field print, but just that national FBI background check. With CJIS, like we said before, you usually just get the tracking number, some basic information about the case, but then you have to do more hunting. With the FBI background checks, usually there is pretty comprehensive
Get
case
more.
information. I can fill out what I need for an expungement petition, the case number, often the tracking number, the, dates of arrest, dates of disposition, the location.
Yep.
It has a little bit more information and can make life easier when you're actually preparing the expungement or shielding or vacatur filings. So you don't have to do quite so much hunting. Not all the time, but a lot of
Yeah,
the time.
but most of the time,
Yeah.
just for a Maryland case, a client with just Maryland, CGIS is fine. So it all depends, really. And we just want to make sure that you know that our partnership has funds for fingerprinting clients. That usually, clients are like $50. We have money for that. And so we can help you with cases that you take through our partnership. We can help with those fingerprinting costs. So some red flag issues for expungement that we just want to make sure you're aware of. If your client is not a United States citizen, use caution. It can, expungement, excuse me, can create discrepancies between state and federal records. If you expunge a case at the state level, that doesn't mean that it is expunged at the federal level. And if the feds can see something and then they're looking for the records at the state level, and they're not there, as they should not be if you've successfully expunged something, that can cause a lot of problems. Immigration attorneys have always told me you keep certified copies of the expungement, and I mean, you keep 4, your client keeps 4, bury 4 in the yard, like whatever you have to do to make sure you have them. I would, I don't know with the incoming administration. I would make sure that you consult an immigration attorney.
I'm strongly, strongly echoing that. Be
I'm not going to
sure
do
you
anything.
consult with an immigration attorney. It's not just if somebody has undocumented
I don't care.
status, it's if they have anything short of citizenship, you should be consulting with an immigration
Yeah,
attorney.
like I would have no concerns about getting an individual fingerprinted, and then doing what I told you about, getting those certified copies. After January 20th, I wouldn't even do that without consulting an immigration attorney. Okay, the next thing to just be aware of is that private third-party businesses that perform background checks, I have these things pop up on the, just because of the work I do, that pop up on the internet all the time for me, that say, do you want to get a background check for this person, with all these crazy names to their businesses. They can't be made to remove records from their databases. And so they may have done a sweep on your client, their record, excuse me, before a record has been expunged, and then they keep that information in their system. And so someone, a landlord or an employer may pull a background check that is wrong on your client because the client may have had stuff expunged. And they generally don't update their information because they don't have to. And honestly, they benefit from making things difficult. And so you're always going to want to make sure that you tell your clients keep everything that is expunged, right? And keep record of everything so that they can show their employer, the landlord, whoever it is, who's like, but wait, you do have a criminal record. And you can show, no, actually, I don't. And then obviously a federal background check can contain cases that are expunged at the state level. And Heather already talked about just some other inaccurate information. And you just have to basically do the tracing paper method. Question about disclosing criminal records. Heather talked about this earlier. Does a person have to disclose arrests on employment applications? The law says no. Once arrests have been expunged, they do not have to be disclosed. However, some employers are still going to have access to records in mystical ways, military, security clearance. In those circumstances, it's generally better to disclose. And then you've got that scary thing about these third-party background check people. And my fear is always that someone is going to be seen as being dishonest because they say they don't have a background check, but sorry, a criminal record, but then someone does a background check through a third party, service, and then they find out that they do. So it's really about having a conversation to say, is it safe to say that, I've been arrested, but I had things expunged, or is it not? So it's all about having those conversations with your client once the expungement process is complete. And it's the same thing about convictions. The law says no, right? If convictions have been expunged or shielded, they do not have to, legally, they do not have to be disclosed. But some employers will still have access to this information depending on the kind of background check they perform. And so it's about making sure that the person is prepared to talk about that if and when the time is right. All right, so Heather's going to start us talking about shielding. I'm going to finish it up and then we will talk about vacatur and we will be out of here. I forgot I have to turn the thing.
There you
Okay,
go.
go
No,
ahead.
I was just commenting. I love our long title. How shielding is an
That's right, an
underutilized tool.
underutilized tool for
It
limited
is.
access.
And shielding, I feel like in our practice areas, we look at shielding because again, we're looking at this deep dive, comprehensive look at any record that we can pull, right? What can we do about it? And there is actually a fair amount you can do with given Maryland's shielding laws, but it's a little bit scattered. And so we just want to walk through the options that you're aware of them. So first, we're going to talk about shielding certain criminal records under the Second Chance Act. And shielding is different from expungement. It's not removing records or removing information. It's instead rendering information about a conviction and underlying police activity, records, the arrest, inaccessible to the public. So again,
Pulling the shade down.
yeah, if we pull the shade down, not every person can just get access to this information. Now, of course, the courts, law enforcement, certain agencies are still going to be able to see this information, but it can be very useful again if someone's applying for a job, trying to find a place to live, because it won't immediately show up the same way a non-shielded record would.
It just limits
So,
public access.
yeah. So under the Maryland Second Chance Act, it's a fairly limited remedy. I will say this is kind of the last thing I look to when I'm working with clients. First it's generally expungement, then vacatur, then shielding in other ways, then shielding under Second Chance Act. But it still is out there. I have used it in the past. An example I'll give is I had a client who we could expunge almost everything on their record. This was a couple of years ago, but they had a conviction for malicious destruction of property. And that hadn't yet been added to the list of eligible offenses here in Maryland. So again, trying to make sure we could address everything we possibly could on the record, we ended up shielding that case to, again, just do what we could. Now that case is eligible for expungement, so we don't have to, look to this remedy anymore for that. And that's been the case with a lot of the things listed in this list of 12 types of crimes that can be shielded under Maryland law. It's things like, prostitution, trespass, malicious destruction of property. Again, a little more low level like misdemeanors that are eligible for shielding under this law. Now, what makes this challenging is under the Second Chance Act, you can only request this type of release once. One petition to remove a court record and police records for one conviction in one jurisdiction, right? This isn't per jurisdiction. There's no kind of
Great.
flexibility here. And where this is challenging is, say, we'll go back to that malicious destruction of property example. Say there was an arrest, the case went to district court, the person you're working with wanted a jury trial, it went to circuit court, and there was a conviction there in circuit court. You could only request for it to be expunged in the circuit court.
Shielded.
Shielded. So the circuit court record could be potentially shielded, but then the district court record would still be hanging out there. So it has a little bit of lessened utility because of all the caveats. Like I said, there's a dozen eligible offenses, all misdemeanors. The Maryland courts actually is a good website on this form of relief, so you can see more details there. And the petition for shielding under the Maryland Second Chance Act, the form also kind of runs you through all the details that are essential to this form of relief. There's a 3-year waiting period after the conviction, and there can't be subsequent convictions. So again, that limits the utility. And like we said already, we kind of look at this option last, but we want people to know about it because sometimes it can be useful.
Yeah, I've used it once.
I've used it a handful of times, but again, it was kind of when there's some exceptional circumstance that made it where something was blocked and we just wanted to get one thing off. So,
Yeah. And
all right.
again, think about it. Once in a lifetime,
Yeah, once in a life.
one jurisdiction and one venue.
Mhm.
Remember what I said about folks that do our work and folks who don't? Anywho. Okay. Now
All
this
right.
I use a lot.
Yes. So this second way that you can use shielding to a client's benefit is also, Jess and I use this very frequently. I'd say sometimes, I mean, I might even estimate over half,
Yeah,
third to a half the clients
yeah.
we work with. We often see situations where people are dealing with family abuse, intimate partner violence. There's protection orders being brought multiple
Back and
ways.
forth between
Traffickers
each other.
exploiting
Mhm.
somebody, and they bring a protection order as a way of maintaining control or threatening a person, reversing the narrative. So shielding can be used uh, to basically remove the information about this record from public view um, if the protection order or peace order has been dismissed or withdrawn um, anywhere prior to the final issuance of the final order, to that final stage. Um, and this is, again, it's very useful because if you look on Maryland Judiciary Case Search, if someone has had a protection order brought against them, or request for a protection order brought against them, or request for a peace order, that'll show up on Maryland Judiciary Case Search. These records are not shielded from the public. They're there. And usually the way that it shows up, especially if it was a domestic violence related protection order, it'll just show up as like the case number under the client's name, and then it'll say domestic violence. Okay. And so again, if you're a layperson, if you're a landlord, if you're an employer and you're looking, you see that, that can be incredibly prejudicial to the client that you're working with.
Again, no
Um,
context behind it.
exactly. What was the context behind? So if a final protection order or final peace order has not been issued, or if there was an order that was consented to at the final stage, you can request for those records to be shielded. There is you can do it immediately, but there is a kind of a waiting period in a way. If you want to request that the record be shielded prior to 3 years, after the last order was made in the case, you have to sign a general waiver and release. If it's more than 3 years, then you do not. And again, that's just to retain the records for potential lawsuits. Um, and there are some additional requirements that have to be met. So a final peace order or protective order can't have been previously entered against the person requesting the shielding by the original petitioner. There can't be any pending peace or protection orders brought by that original petitioner. You can't, the person requesting the shielding can't have been convicted of a crime arising from abuse against the original petitioner. And there's no criminal charges that are pending against the person requesting the shielding related to abuse against the original petitioner. It's a it's a mouthful, all of these caveats. It's spelled out in the forms, which we have down there,
Very, very clearly,
very,
actually.
very clearly. And it's good to go over those, specifically with your clients, because those are the questions that will be asked at the hearing. So a hearing is mandatory in this case, and it's also mandatory to give notice to the original petitioner that this person is now requesting this record be shielded. We sometimes I'm working with clients who have no idea where the original petitioner is, and so we request service by the clerk. Sometimes that doesn't happen, and the clerk will say that we need to, give us the last known address. We have to give notice. Sometimes they will serve. It depends on the court. I have rarely had a original petitioner show up to the hearing. Now they can, and there's important reasons for that. If they want to explain why they think this record should not be shielded or object to it. In my experience, I've actually only ever had someone show up to support the shielding of the record, because and they actually explained to the judge this was just a dispute they were having. They did these remedies, but now things are okay, and they don't want it to be hanging over the head of the person who was the original respondent.
And some
Um,
courts I've been able to have these hearings virtually.
Yeah, I've had a few too. Yeah, yeah,
But
yeah. So
regardless, you still have to make sure you're
but
talking
you
to
still have to go.
the
I will say when I've gone to court for these matters, if somebody doesn't show, the court will not grant generally. There has to be a hearing, the petitioner has to show. Or the person who's I'm not gonna say petitioner, the person who's requesting that the record be shielded, which is the original respondent. The original petitioner is the person who brought the protection or peace order in the first place. So it's a little confusing, but it's actually not a hard remedy to pursue.
no.
I think sometimes people are intimidated by the fact there has to be a hearing, but they are the fastest and easiest hearings I've ever had, to be quite honest with you. And
And
again,
usually the
yeah,
judge will, sometimes, usually the judge will give you the option to ask the questions, those core
yeah.
questions to the client, which
Hmm.
can
Hmm.
calm the client down as well. Like they
Hmm.
don't have to even talk to the judge.
I've had it both ways.
Yeah,
Yes,
I've
sometimes
had
the
it
judge,
both
they have
ways
their script, they just launch into it. Yes, 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 or no, however
or
the
not.
questions are phrased. But I think it's something that's overlooked and it's an important remedy for folks. So we
Because
want
it
to,
looks bad.
yeah. All
And
right.
then just note that protective or peace orders that were consented to can also be shielded, but there are some additional requirements.
Mhm.
Okay.
And I see we
Oh,
have a
sorry.
question about what happens when you use shielding, but later, within 3 years, the conviction was no longer determined to be a crime. Would you be able to request shielding later for the client? So
Shield. Do you mean
if
expungement? I think they mean expungement.
I mean, if something is determined to not be a crime, then it immediately falls into the bucket of crime no longer a crime and is eligible for expungement, regardless of whether it's been shielded in the past, right? Like you can have something that's shielded and then go back
So
and
I've had that happen.
yes, and I've done that
Um,
before too.
and what you have to do is actually petition the court to unshield
Yep,
the
yep,
record.
yep.
And then so that opens that back up again, and then you can expunge it
Yes. And
regular
we've
style.
done that. I mean, again, when we have clients that have things that we've shielded in the past, and again, I go back to my malicious destruction of property example because that's a more recent one. We've then requested the court to unshield, petitioned for the expungement, made sure everything tracked, everything's gone from everywhere. You still want to keep records of all of this because it's a roller coaster. But yes, expungement is better.
Expungement is way better.
Way better.
Yeah, because expungement, just so that folks know, if you actually poke around in, so regular old expungement is 10-105 of the criminal procedure article. If you poke around in the earlier 10-101 plus, it actually says that what happens is the files are kind of removed to this area for a period of
Mhm.
time
Mhm.
while so just so and for those of you who know this, just tune out. What happens is the court issues an expungement order, which then gets sent to every agency that's listed on the expungement order, right? And some people don't think about like the ins and outs of what actually happens. That expungement order then gets sent to all of those agencies who they are the ones who then have to expunge and destroy those records. And that can take a while. They're supposed to do it within 60 days, but girl, that does not happen.
Mm-mm.
So, so they have to, so the court has to be able to kind of retain access to those records because there's always questions and I can't find the order and blah, blah, blah. And so they put the records kind of in like a secret bat cave where nobody has access to it. And
Totally
then
that.
eventually, within 3 years, they physically destroy the records. So
Mm,
it is as that's why it's way better. It is like the physical, it ends up being the physical destruction of the records. So the
mhm.
answer is never stop with shielding. If
Yeah.
you find out that your client has exactly like with malicious destruction of property, like don't stop with shielding.
Mhm.
Unshield that bad boy and then expunge it for sure.
And like every legislative session, we're all part of these coalitions, right? Like MVLS, we usually try to do a legislative updates webinar in the fall, and we'll put out like blog posts and social media notices of like what's new that can be expunged
Yeah.
because the law is ever changing. And again, of course, we all wish we had tons of time to go through every single one of our past clients and see what could be expunged. But if you remember, and I do sometimes, I remember my client was so frustrated about the malicious destruction of property, right? Like I remember it. And so we're like, okay, we got to revisit
Reach
that.
out.
So if you can, it's a great thing that you can do for folks or just help spread the information.
Yeah. But you can't remember
Forward on the
everything,
the
and
MVLS
you
update
try.
to people you've worked with on expungement if you still have their email addresses.
Yeah.
You know what I mean?
Yeah. All right, the next thing is pretty newish. And so I'm gonna actually go over it because I haven't even done it yet. So this one is not as new. Okay, so there is a request to shield that is specific to COVID. Okay, so if another thing that comes up on your record that doesn't look good are these failure to pay rent cases, right? And so if a landlord is looking at your record on case search and they see these multiple failure to pay rent cases, that's going to give them pause. And again, no context to those cases is going to be a problem for your client. So you even want to look at those cases, right? So if a case for failure to pay rent was caused by hardship due to COVID-19 and was filed, during that main period of the pandemic, on or after March 5th, 2020, or before, but including January 1st, no, actually not including, before January 1st, 2022, the tenant may petition the court to shield. And again, it doesn't, the there is still there, but it'll be off case search to shield the court records related to that case, regardless of whether a judgment of repossession was granted. So that means regardless of whether the client had to get the heck out of the property or not. Okay. And so that's obviously something that's very specific to COVID. We've linked to that form. It's very self-explanatory, very easy. From what I've heard, courts are pretty easy-ish around this. But the brand new piece that I haven't even done yet, but I am on my way to do, is a law. It was SB 19 from last legislative session. It was enacted October, or went into effect on October 1st, 2024. So for failure to pay rent cases that are filed after October 1st, 2024, so present cases, any case that did not result in a judgment of possession, so if the client doesn't get kicked out, will be automatically shielded within 60 days after the case is closed. Nobody has to do anything again, okay? However,
And
yeah,
and I have
good.
an update. We have
Yeah.
heard from the courts that this is actually happening. Like we actually
Really?
just got word, yes, that
Hey, all right.
it is happening, that they actually looked back to like records going back to August. So very
Really?
exciting that
So
this
they're doing it
automatic process
retroactively.
is so swiftly being implemented.
Beautiful.
Yeah.
Okay. And that is just, right? Because why do I have a failure to pay a rent case if I remedied it and I'm back in my apartment? But what's really cool is that even if the case did result in a judgment of possession, the court may. Now there's a difference between may and shall, right? May means they could, but they don't have to. May still shield the case if the tenant exercised their right of redemption. And I put a little definition just, because not everybody who's going to take these cases is a landlord tenant person, and I'm not either. So in Maryland, the right of redemption means a tenant's ability to pay all the rent and fees due to a landlord before an eviction occurs. And this allows the tenant to remain in the property. So even though there was a judgment of possession that was entered, the person remedies it and stays in the property. Okay. So if there's a judgment of possession, the person remedies it and stays in the property, and at least 12 months have passed since the final resolution of the proceeding. Okay. The person can actually petition to shield that failure to pay rent action from case search. Now, it doesn't mean that the judge has to say yes to shield it, but they can. Now, the piece that I love is that or if other good cause exists to shield the case. I have a case where the client is a survivor of trafficking and was essentially taken, eventually, not like taken like the movie, but because we all know that that is not real. But she was being trafficked and her trafficker moved her. And she obviously there was failure to pay rent because she wasn't there. Um, and then obviously she didn't exercise her right of redemption because she wasn't there. And it looks pretty bad on her record. And I am wondering if that is good cause enough to have the judge shield the case on case search. The only thing I'm a little confused about is if this has to be a case after October 1st, 2024.
I'm assuming, yeah.
Not.
I mean, it's really tough because like
It's
I
not.
feel like this good cause caveat is something that folks have been working on in the expungement space.
I know.
It's useful everywhere, right? Because
It's
sometimes there are
fabulous everywhere.
just extraordinary circumstances that really make this unjust. And we all know, everyone in Maryland, at least, we have a housing crisis. It's hard. I can't tell you, housing is one of the things that our clients are
Ugh.
struggling with the most. Being able to find a rental, being able to it's
And
almost
then
like
once you find
competitive
it, be
sport.
able to be accepted for the victim.
Exactly. And so, having landlord tenant eviction related records publicly available, these can all be seen on case
Yeah,
search. These are not shielded, makes it really hard for folks to be able to get stable, safe housing.
right.
And so we're really excited about this, and we'll keep the community posted as we move forward with trying to
Yeah.
address some of these cases, because we do see that's always been a tough thing when folks say, oh, I have so many, of these eviction or, cases, and I tried to remedy, or I did remedy this time, and then you're like, oh, we just don't have much recourse. So it's exciting that this is now.
Yeah, this is really cool. So we wanted to make sure that that was on there. It's very new, obviously.
Mhm.
So that's there.
And we'd love to hear from folks. If you or someone in your firm or at your organization is trying to leverage this remedy, please let us know. It's something that we as advocates all need to
Yeah.
kind of stay on
Or
top of.
if you have feedback for us, or if you want to take this case and let me watch. That would be-
Contact me, pro bono placement. We're
Yes,
excited.
please contact Heather. All right, in our last 15 minutes, I want to go through vacatur for survivors of trafficking. Okay. Why does this matter and why is this specific to trafficking survivors? And the reason that this is specific to trafficking survivors is because they commonly have criminal records. As Heather intimated, every arrest or most arrests, regardless of whether they end up in court, is a matter of public record. Most will show up on background checks or Maryland Judiciary case search. And the reality is that human trafficking victims are often arrested for acts they were forced to commit by their traffickers, as well as acts stemming from the instability that so commonly precedes and or follows a trafficking experience. And as much as we try, and we do try here in Maryland, human trafficking victims are rarely identified as such at the time of arrest and or prosecution. Criminal records can prevent survivors from obtaining and keeping employment, receiving housing assistance, pursuing their education, public benefits, applying for credit or loans, maintaining their stability of their families, accessing immigration relief, or adjusting their status. And if you can't do all those things and you are and in addition, you are also a trafficking survivor, you're going to really struggle from healing from trauma. And if you take a look at that, that wheel, it's just one thing after another, and you're in just a cycle you can't get out of. So that's why this is something that's really important, that's specific to trafficking survivors. So as we always do, we give you a definition. This is different than shielding and expungement. And this is shielding and expungement. Sorry. Yes, that's what I meant to say. Shielding and expungement take no issue with the why. Shielding and expungement are formulas. If you have A and B, then it equals C. right? This undoes a court's judgment. This returns the movement to the position they were in prior to the conviction. This takes issue with the why, which is what expungement and shielding don't do. They don't care about the why. It's just if you meet the formula, then you're eligible. So yes, again, it is different than other forms of relief. This means that there was an error in the original judgment. And so while all forms of criminal record relief, everything, right, helps everybody have an easier time getting housing and jobs, vacatur contains the added emotional benefit of acknowledging that the law made a mistake. Okay. And again, obviously, vacatur is not the only form of criminal record relief available. And I will say that, the better expungement gets, the less I use it, but it doesn't matter. It needs to be here because it is important for certain clients to be able to do this, and it's important for other clients to not have to do it. So it is Maryland Criminal Procedure Law, Section 8-302. We're not going to go through all of it, but the gist of it is that a person convicted of a qualifying offense, which you'll learn about on the next slide, may file a motion to vacate the judgment if the person's participation in the offense, a combined offense and direct, was a direct result of being a victim of human trafficking. And the definition is the legal standard is established by Maryland sex and labor trafficking statutes or the federal statutes, the forced labor trafficking generally, the sex trafficking of children or adults, the attempted trafficking statutes of the federal code. So there's a lot in there. And again, if you're more curious about that piece, we have that available for you on our websites, trainings on that available for you on our websites. Those are the qualifying offenses. You'll see they're pretty similar. I think we need to update those because they're not even actually up to date with the expungement. But again, I wish they were much more. But there's a time and a place. Expungement had to do its updates, and now I think it's time for vacatur to update. The legal elements, that's what's most important for the people on this particular webinar. So the first thing you have to figure out is the conviction eligible, right? Because if it's not, you have to stop there. The next thing is, does the client's experience meet the legal definition of human trafficking? If they're not a trafficking survivor, this is not the legal recourse for them. The next thing you need to consider is the nexus to the arrest or conviction. Did the conviction arise as a direct result of human trafficking? Now, listen, I am all for pushing the boundaries on this, but if the person was a victim of trafficking back in the 60s and they've got a conviction tomorrow, you're going to have a hard time tying that. Although if you can do it, I am going to support you. That being said, I have had success stretching that boundary. And so, the more we can do it, the better it is for the client. And then due diligence, motion been filed within a reasonable time, as long as the client, is just kind of working with you on this and being timely, you're all good with that piece. Some important considerations, obviously we improved the number or increased the number of qualifying offenses when we updated this in 2020. We finally got labor trafficking survivors to be eligible. Before this, the only thing that was eligible was prostitution. And that's not short-sighted on Maryland's behalf. This was kind of what we thought when we first passed this law, and this is what everybody thought. I've been involved in this since the very beginning. And this is what we thought in general of trafficking survivors. We thought prostitution was it, and then we realized it wasn't. We also eliminated the consent requirement. Prior to 2020, we actually had to get the consent of the state's attorney in order to be able to file the petition, which is unconstitutional. But regardless, that being said, we always
Fixed now.
Whatever.
Better to partner, always better to collaborate.
Absolutely. I think not only is it best practices just in general, I also think it's healthy and healing for the client to see that, right? We work in collaboration and cooperation with the state. There's a requirement that if the crime that you are seeking to vacate has a victim, that if the crime happened within 5 years, that you try to notify the victim. And then as far as the direct result, I actually really like this. Um, the nexus requires that the judge consider the dynamics of the trafficking relationship. So if this is, a newer trafficking relationship, I think that nexus is going to be need to be tighter. But if this is someone who's been harming this person for decades, I think the nexus can be, a little further apart, because you can help the judge understand the impact of coercion and the impact of, the impact of trauma and what that does to help a trafficker keep control of someone. And then I love the any other relevant evidence piece, because you can really do a lot of educating around maybe why this person was doing these things, committing these crimes, quote unquote, when they were not necessarily under the trafficker's thumb at that particular time. So there's a lot of stuff in there for you to be able to use to educate both the state and the judge about trafficking and the impact of complex trauma. There's also the option for the judge to grant a motion without a hearing. We've had some complications around that, but again, we will make sure to guide you around that. But that's nice for clients who want to be nowhere near a courtroom. But there's also obviously the in-person option for clients who want to go in person and hear that their convictions have been vacated. A judge can dismiss a motion without a hearing if they find that the person is ineligible, or that the motion's been brought in bad faith. The other change that I think is great, the previous version of Maryland's vacatur law, there were options. Basically, the judge did not have to vacate the convictions, and now they shall vacate the convictions. They also have to state the reasons on the record, which is fantastic for, maybe a client who has convictions in other jurisdictions, because you can use that as evidence for other motions to vacate. And then those convictions are immediately expungable without a waiver. Because what you have to remember is you've got a conviction, right? You are removing that conviction, and then the judge essentially has to redispose of the case, either through a dismissal, or if you're working with the state will request a nolle pros. And then you still have to dispose of that newly disposed case, or else you'll just have nolle pros and dismissals on the person's record. So you have to be ready to expunge those cases right away. And then there is language in the new law that is essential, that says once this thing is expunged, or excuse me, once this conviction is vacated, it is not to be considered a conviction for any purpose. And that is actually very important for any non-citizens who have their convictions vacated. Some limitation, it only applies to convictions. So any arrest for qualifying offenses that resulted in the defendant pleading to lower or alternative charges would not be eligible. It doesn't allow the court to take additional appropriate action beyond the plain language of the statute, like some other statutes do, like New York's. And it doesn't provide a presumption of eligibility if maybe I was able to produce a T visa, right? And then maybe I could file like an amended petition. Now you can still negotiate that with the state, but within the statute, there's not a presumption of eligibility. A couple of other things: no explicit confidentiality provisions. You need to file under seal to make sure that this information is not out there in the public. There's no automatic expungement. And then just being complainy. There's no funding, but there's no funding for anything. So I just like to do that because I like to complain about lack of funding. Um, but again, just to return to the reason that this matters is that this is language from the 2012 Trafficking in Persons report from a US born trafficking survivor who was criminalized. And she said, I always felt like a criminal. I never felt like a victim at all. Victims don't do time in jail, they work on the healing process. I was a criminal because I spent time in jail. And so the bottom line for trafficking survivors is that a criminal record often keeps survivors trapped in the very industries they seek to escape, prevents them from healing, and makes them vulnerable to re-victimization. So when we have trafficking survivor clients, we use all of these things that you've heard about, right? The shielding of all the things, the vacatur, the expungement. We realized that the last minute that we didn't even put a slide in on pardons. We've done that. We do all the things to try
And
to get everything that we can off their record. And we do that with all of our clients, but with trafficking survivors, there's that additional piece of the injustice of having a criminal record for something that was a crime that was committed against you. And that's why I started the HTPP all those years ago.
And, these vacatur filings are complicated. Expungement filings, the analysis can be complicated leading up to
Filing's not.
decisions to file, but the actual filing is pretty straightforward. Same with shielding. And we're just here because we want you to be aware of all of these tools. And you're not alone in this. We are here to help provide support, answer questions. If you're on the MVLS volunteer panel, you can always reach out to myself, to Chris Sweeney, our workforce development manager, to
We love
ask
Chris.
questions about any type of criminal record relief you're pursuing for a client. We have tons and tons of examples on our website. I can actually, let me see if I'll find that and I'll pop it in the chat before we go. And I realize we're going a few minutes over, but you can just put up the best practices. I'm not going to go in depth about these things. We just want people to be aware of some questions that they can ask when they're working with anybody and asking about criminal records. I mean, those last 5 questions, were you ever arrested? What states? Do you know what you're arrested for? Do you have any current open records, open warrants? Have you gotten a fingerprint record? I would even back it up further and just ask anyone you are working with if you
Yeah.
are able to help with expungement or shielding or criminal record relief. Just ask, have you had encounters with law enforcement? Like a really broad question. And if they say yes, then you should be talking about these criminal record relief options. And again, we're here to help. We're here to help clients. We take referrals both through the HTPP. If someone meets the criteria that just put out, or MVLS, people can just call our intake line. But we really want folks, we don't want this to be a barrier for folks, for anyone in this state. And you want to learn some more? We have tons and tons of past webinars, more detailed dives into some of these topics on both MVLS's and the HTPP's websites. We will send a follow-up email with links to this, as well as a link to this recording. If you're interested in making a referral, you can visit htprevention.org, hit the Get Help tab, and you'll be able to easily do that. Or if someone just wants to request legal help from our partnership, that's where they'd go to. If you are an attorney and you're interested in volunteering with these cases, I have a couple of expungement cases and shielding cases I need to place right now. Please reach out to me. I'd love to hear from you and we can talk about this. You want to do
And
a
I have
deep
a really
dive?
cool other one that I'm about to ask Heather if we can
Yep. You want
place.
to do a deep dive with vacatur? We are here to guide you to review documents, to help facilitate communication with the client and support you in every way we can. So please reach out to me via email. Love to have a chat with you. If you want outreach materials, again, reach out. We're happy to send you a care package. Sometimes there's chocolate inside as well.
Forgot that you do that. Yes.
Otherwise,
Let's do
here's our
that.
contact information. Thank you so much. Yes, and the PowerPoint, the recording, and a tip sheet will be appearing on our website, hopefully within the next month. We will send an email out as well to everyone who registered so they can get access to these resources. And thank you everyone for joining. We really appreciate your time today. And you can check out MVLS's website and our calendar for upcoming Third Thursday presentations, which often feature our partnership with the HTPP and topics relevant to that issue. So yeah, this month is Human Trafficking Awareness Month too. So again, we particularly appreciate your listening to us talk about these different remedies with that area of focus and that perspective. Hope you all have a great rest of your day.
Two things before we go.
Oh, sure.
First is that we will be having a webinar on the criminalization of labor trafficking
Yes.
at the end of March. So you'll hear more about that. And then Abhishek. Sorry. Now you can close this out. Sorry.
Thank you so much, everyone.
Thank you.
Bye.